United States, the great state of Florida, and this honorable court.
Please be seated. We have two cases on the docket scheduled for oral argument this morning. After oral argument in our first case, we will proceed immediately with oral argument in our second case. First case scheduled for oral argument this morning is State of Florida Agency for Healthcare Administration and andMolina Healthcare of Florida versus Best Care Assurances. Counsel ready to proceed?
Yes, Judge.
You may approach counsel. Again, we have reserved 15 minutes per side for this oral argument. Would you like to reserve some time for rebuttal?
I would, Judge. Thank you very much. And may it please the court, I'm Daniel Nordby from Schutz & Bowen on behalf of the Agency for Healthcare Administration. With me at counsel's table is Ed Lombard representing our co-appellant, Molina Healthcare. I'd planned to take 8 minutes during our initial allocation of time for the Agency for Healthcare Administration, reserving 4 minutes for Mr. Lombard, and then reserving 3 minutes for rebuttal. Judge Lewis, as you've said, this is the first of 2 arguments that you'll hear today, and both arguments involve the same parties. This case is an appeal by ACA and Molina of the Circuit Court's final judgment in favor of Best Care. And unless the court would prefer otherwise, I'd like to begin with the issue that we would submit as dispositive in this case, Best Care's failure to exhaust its administrative remedies. And this case really exemplifies why the exhaustion requirement exists. In more than 100 pages of briefing across the 2 cases, Best Care has not cited a single case in which a party has been permitted to simultaneously pursue identical relief in both the state courts and through the administrative system. And in the 2 cases that you have before you this morning, you have an appeal of a final judgment from the Circuit Court and an appeal of a final order from the Agency for Healthcare Administration on the same issue, reaching diametrically opposed results on the question of statutory interpretation. Best Care should have been required to complete the administrative proceedings that it had already begun at the time it filed its Circuit Court complaint, rather than to simultaneously pursue the same relief in both the state courts and before the agency. Here, at the time Best Care filed its complaint in the Circuit Court, it had already filed and was continuing to pursue its relief through the administrative process. It's well settled under this court's precedence that a party must exhaust its administrative remedies, including appealing from adverse administrative rulings.
Were they asking for anything different in this case than they were before the agency?
They weren't, Judge Winokur. They were asking in both cases for ACA's contract award to Molina Healthcare to be canceled. Best Care was a winning bidder under ACA's statewide Medicaid managed care procurement, and in both of these cases, both in the administrative forum and in the Circuit Court, they were seeking a cancellation of a contract that ACA awarded to one of their competitors in Region 8, which is a region in Southwest Florida. They have asserted in the Circuit Court that an exception to the exhaustion requirement applies in this case.
Did the Circuit Court find an exception that applied to the exhaustion of administrative remedies doctrine in this case?
It did. The Circuit Court found that the exception that Best Care had asserted applied in this case. We think that ruling was in error for 2 reasons. The first one is that even where the exhaustion exceptions apply, there's no suggestion in any of this court's cases or any other case cited by the parties that an exception to the exhaustion requirement allows a party to simultaneously seek relief in the state courts and in the administrative forum. But we would also say that the exception does not apply in this case. The exception that was cited was outlined in this court's Baker County Medical Services case, and it applies where an agency acts without, quote, without colorable statutory authority clearly in excess of its delegated powers. Now, in the Baker County case itself, this court said in the opinion that the agency in that case was unable to point to any statutory authority supporting the actions it had taken. That's not the case here. ACA has pointed to exactly the statutory authority that it is relying on here. ACA has the authority to settle administrative protests under 120.57.4 of the Florida statutes, and ACA has also explained on the merits why 2 separate statutes within Chapter 409, the Medicaid statutes, authorize the decision it reached in this case. Even if the Circuit Court disagreed on the merits with ACCA's interpretation of the Medicaid statutes, it should still have dismissed the complaint for failure to exhaust administrative remedies and required Best Care to pursue its protest where bid protests are ordinarily resolved, through the administrative forum. Under no circumstances should Best Care have been permitted to pursue both remedies simultaneously. The Florida Supreme Court in the Key Havens case that we've cited in our briefs said that once a party chooses one or the other alternative, he is foreclosed from proceeding with the alternate remedy. We think that principle applies to this case as well, and that Best Care should have been required to complete its administrative proceeding, including an appeal to this court, rather than to pursue the remedy in the circuit court as well. The APA provides a remedy for Best Care to obtain a review of ACCA's contract award.
Counsel, let me make sure I understand your argument. Besides, I know part of your argument is that they can't argue, there's no case that allows them to argue the issue simultaneously. But as far as the exception goes, is it your contention that the agency must be acting with no statutory authority at all in order for the color of law argument to apply? And if they can at least point to a statute that they're applying, then that argument doesn't apply. That exception doesn't apply.
I think it would be overstating it to say that it only applies where the agency can point to no statute. The language in the Baker County case says no colorable statutory authority, clearly in excess of its statutory authority. I think probably a good analog there is that if the agency can make a non-frivolous argument, here ACCA certainly made a non-frivolous argument as to its statutory authority, then what that means is that the appropriate place to resolve that case is through the administrative process rather than in circuit court. But again, even where that exception to exhaustion applies, a party can't pursue both remedies simultaneously.
Do you think the trial judge was actually clear on stating definitively that there was a failure to exhaust because of lack of colorable statutory authority? I thought it was interesting. Best Buy even noted that it was implicitly stated in the trial court's order.
Judge, I would agree with you that it's not entirely clear the basis for the trial court's ruling. I think the citation to the Baker County case is a strong suggestion, and then the transcript from the hearing itself and looking at the arguments that the parties were asserting that led up to that final judgment, I think it is reasonable. The best and most reasonable conclusion is that that was the exception to exhaustion that the trial court relied upon. I would like to talk, unless the court has further questions on exhaustion, I'd like to briefly touch on the merits arguments, understanding that those merits arguments are also at issue in the second case that you'll hear today. Even if this court were to conclude that the trial court appropriately reached the merits decision, the final judgment should be reversed on the merits because ACCA's interpretation of the two statutes involved here is a more reasonable interpretation than the one advanced by Best Care. The interpretation advanced by ACCA and by Molina best gives full effect to the two statutes that are in place here, 409.974 and 409.9663E, and it gives full effect to the entire legislative scheme that the legislature has enacted. Statutory interpretation obviously begins with the plain text of the relevant statute. Whereas here, though, the legislature has enacted a comprehensive statutory scheme, which the legislature has done in enacting statewide Medicaid managed care in 2011, all related provisions of the statutes must be construed in pari materia to give effect to that scheme. The two statutes that must be construed together here are Section 409.9741H, which provides that ACCA shall procure at least 2 plans and up to 4 plans for Region 8, and Section 409.9663E, which provides that ACCA shall award an additional contract in any other region to each plan with a contract award in Regions 1 and Region 2.
But Counsel, my understanding is that's not actually what happened, though. My understanding is that they awarded it to 4 contractors, like 4 plans, and they then awarded, in other words, at that point, they could have awarded a contract to somebody who had a contract in Regions 1 or 2. But They didn't. They awarded it to Molina, who did not have a contract, and Regions 1 and 2. So it seems to me that if it were Humana, if there had been 4 and Humana had come along and said, we deserve an additional contract under, 966, that would be all right. But Molina came along and did that instead. Why is that different?
It's different for a couple of reasons. One is factual and one is legal. The factual reason is that when ACA posted its initial award to 4 different contractors, the award to Humana was specifically indicated as an award of an additional contract made under 409.966.
So there's a little asterisk by Humana's, and that we're reserving our ability to award a 4th one. This one isn't really the 4th one, because it's just an extra one.
And that's right.
I'm not sure if the statute really reads that way.
Well, and let me try to persuade you otherwise. The award to Humana was indicated by the asterisk, and what that means is that Humana was awarded that contract not because Humana was one of the top 4 under a best value determination. So the 4 contracts that are awarded under 409.974 are procured and awarded based on a best value determination under the ITN. The contract awards, the additional contract awards under 409.9663E are not awarded on the basis of best value. They're awarded on the basis of the statutory criteria there, that the plan was awarded a contract in Region 1 or 2, it submitted a responsive bid in another region, and it negotiates a rate acceptable to ACA in that other region. So Humana's award was not awarded as one of those best value ones under the ITN, which, and as it was indicated in the time by the asterisk, that did reserve for ACA the ability to procure and award that final contract in Region 8, which it ultimately did through a settlement with Molina.
Counsel, you're well into Molina's time.
I will sit down then unless the court has further questions of me. Thank you.
Good morning. May it please the court. Ed Lombard from Brady Law Firm on behalf of Molina Healthcare, and I'll do my best not to eat into Mr. Nordby's rebuttal time. Just following up on a couple of questions, I just want to reemphasize the 966 question that you asked Judge Winokur. It wasn't just an asterisk. It said at the bottom of the notice, this is a 966 award. So the Humana award originally published plainly put everyone on notice, or the agency put everyone on notice, that was considered bonus award pursuant to that statute. The Molina award that was posted later, it was clear that that's not what they were giving us. They were providing us a standard contract under the other provision of the statute. So I just want to make sure we were sort of all clear on that.
Well, and isn't there a semantics distinction? What I found important was one statute says procured. So could we say there's a category of procured contracts and then there's a different category of awarded contracts?
I think that's a critical distinction. And the reason for it is the legislature is saying, okay, we've got this amount, whether it's from 2 to 4, that they're directing ACA to choose plans based on qualitative assessment. They're saying which are the best ones, and they actually in the statute list out several criteria that are minimum baselines that ACA must consider when picking those plans. And then you turn to 966 where it talks about the additional award, and none of those criteria matter for purposes of that bonus award. Why? Well, the legislature has found that Regions 1 and 2 are underserved, and so they're trying to encourage plans to bid those. And so to encourage them, they're saying, look, if you win in Regions 1 and 2, you will get a bonus award. You'll get this additional, we're going to give an additional contract, not based on best value. Whether you're good, bad, or indifferent, you're going to get that award as long as you are responsive to the requirements of the procurement, and you give us a rate that's acceptable to the agency for the services. So there are different classes, if you will, of contracts. And the way we interpret the contract, the statute, affords that minimum level of quality plans, 2 to 4. You don't eat into those, and then you get this additional plan that maybe it's really good, maybe it's not, but the legislature made a policy decision within the statute to say, whether it's the best one or not the best one, to encourage participation in Regions 1 and 2, we're going to allow ALCA and direct them to give this additional award. So with that, I'll sit down so I don't eat more of Mr. Nordby's rebuttal time. Thank you.
Thank you, Counsel.
May it please the court, my name is George Levesque with the Gray Robinson Law Firm. I'm here with my co-counsel Ty Jackson of the Gray Robinson Law Firm. We're here on behalf of Best Care Assurance. Before I get into the meat of my argument, I want to address a couple of things first very quickly that they raised. The administrative proceeding, while there were similar arguments that were raised, they were not identical arguments throughout. For example, in the administrative proceeding, one of the arguments that was raised that was only raised there, and we didn't raise it in the complaint because we didn't feel that we had standing to necessarily do that, was whether Molina was a responsible or responsive bidder in terms of the procurement process. So that is one distinction where the things that were being pursued were not the same.
Is that something that you could have raised before the agency?
We did raise it before the agency. We didn't raise it before the circuit court. The only thing that we sought before the circuit court was under the declaratory judgment statute.
Right, but what you did seek before the circuit court, at least this what the agency's counsel says, is the same thing that you sought before the agency. That is the cancellation of Molina's contract.
Correct. That was the ultimate result, and before the agency, to the extent that we were also arguing that Molina wasn't a responsive or responsible bidder, that would have been the ultimate result. But it would be inaccurate to say that all of the claims in both proceedings were identical.
Well, I agree with you, but certainly all of the claims in this proceeding, the circuit court proceeding, were made in the agency proceeding.
Correct. The notion, though, that it is improper to pursue both claims in both courts, I would refer the court to the Florida Public Employees Council case versus Department of Children and Families, 745 Southern 2nd 487. There, in that case, they did permit simultaneous proceedings to go forward. The court discussed the futility of having to litigate in both forums, or at least in the administrative forum, first to conclusion before you could even begin in circuit court. So I think that case is the authority that we rely on, that we were proper in seeking the relief that we were seeking in the circuit court. Now, I think the main issue that this court needs to resolve is whether the trial court was correct when it interpreted 409.9.
Well, before we get to that, counsel, please address the substance of the exception that allowed the circuit court to address the merits.
Sure.
The agency's counsel says that that she misapplied under colorable argument. Why is that a correct ruling?
Appellants argue that the trial court should have never reached that issue. The court had to look at the allegations that we made related to the agency's interpretation of the statute. But the exhaustion of remedies does apply. These arguments were presented to the trial court. The trial court rejected them for very good reasons. A couple of things to note about this exhaustion doctrine and the exceptions to it. First, it's judicially created. It's not jurisdictional. It is something that the courts have created to provide deference to the executive. What it does is it allows the agencies to develop a factual record that, to the extent necessary, or it allows the courts to rely on the agency's expertise in developing the record.
Could you address more specifically, because I know we're tight on time here, the issue of colorable statutory authority, and specifically, why wouldn't these statutes provide a foundation for ACCA to have done what it did?
Because I think the statute, the plain reading of the statute, 409.974, says the agency shall procure. I understand that opposing counsel has raised the issue of, well, there's a difference between procure and award. They're still procuring a contract, and it limits the procurement to 4.
Well, I guess that's getting more into specifics of our merits argument from a procedural standpoint, from a standing review on that exception. You know, the merits of the argument on statutory interpretation, does that really apply? Or is the focus really, is there a colorable statutory authority that's available for a standing argument, not for necessarily merits of statutory interpretation.
I think they go hand in hand, but certainly to the extent that the statute plainly says, and under the canons of interpretation, it says shall procure no more than 4. It procured 5 plans, not 4. It awarded 5 plans under the procurement provisions. The point that I would also make is that, to the point that you were making earlier, Judge Winokur, when ACA announced the awards, they announced awards to 3 comprehensive plans and 1 plan to Best Care. Best Care was the only PSN that applied. The other comprehensive plans that were awarded plans were Well Care, they were ranked number 1. Sunshine State was ranked number 2, and Humana was ranked number 4. And they had the asterisk by Humana. I don't think the asterisk was indicating that there were still a vacant spot that they could use. It was explaining why Humana, the number 4 awardee, was getting the award instead of the number 3 awardee getting the award. That's what I believe ACA intended when it announced that. So they did announce 4 plans in that procurement: Well Care, Sunshine State, Humana, and Best Care. What they're really doing is a post hoc justification saying, we're going to give a Molina this. They've never done that before in any other proceeding, either in the last term or in this term. This was something unique, and it was a justification that was provided after the fact.
Counsel, you argue 974. The appellants argue that the trial court should have construed 974 in pari material with 966. Shouldn't the trial court have construed the statutes in pari material with each other?
It absolutely did. You can interpret that statute as not being incongruous. They seek ambiguity where there is none. There is a hard cap. The legislature, if you're going to apply the canons of construction, it's not as if the award of the contract, which is really just the culmination of the procurement, it's a subset of the term procure, I would argue, not something that is separate and apart from it. If you look at the way the legislature crafted the statute, it knew how to draw exceptions, because in 409.974, paren 4, it created an exception expressly from the regional plan limits for the Children's Medical Service Network. It knew how to do it. So where it has expressed, it has demonstrated that ability and expressed the exception, you shouldn't be reading other exceptions into it unless the legislature has expressly done that.
Well, the legislature presumably also understood how to create a cap explicitly. And I'm not sure if they did so here when they said procure at least 2 plans and up to 4 plans. That's the agency's argument, is that it's not necessarily a cap. It's not a cap of 4. It just says that they have the authority to procure at least 2 and up to 4.
There are other provisions of the statutes that talk about the need for procuring a limited number of plans.
What are those?
I believe it's in the paren 1 of that statute. In regards to the no more than 4, I would argue and contend that where the legislature says at least 2 and no more than 4.
It doesn't say no more than 4.
Up to 4. Up to 4 certainly seems to be setting a ceiling. I think it's a hard ceiling. If one were to say up to 4, I would think that it would preclude 5, 6, and 7.
Suppose every single region has the maximum, as you see the maximum, except Region 1. And there's I think there's only 1 authorized for Region 1. So a plan says, well, we've got an opportunity here, but we're going to have to bid on Region 1 in order to get that opportunity in the statute. They're able to get the contract, and they say, okay, we would like to invoke our rights under 966 and have an additional contract in one of the other regions. Is ACA required to tell them, sorry, I know the statute says we must do it, but those plans are all capped. And so we cannot give you your rights under Section 966.
Well, I think with the way they procure, with the way ACA procures it, they're going to know who the Region 1 and 2 participants are before they procure the other regions. So it's not as if.
Well, it's just hypothetical. Would they be required to not give them the additional contract if all of the other regions are at the maximum stated in 974?
I think if you are, let me see if I can frame it this way. I think if you're a Region 1 or 2 participant, you're entitled, if you meet all of the other requirements that include the negotiation with ACA and the reaching of the mutual agreeing terms, you're entitled to a contract in another region, assuming all those others equal particulars are met.
Well, what if the other regions are all at their caps?
Well, I think ACA is obligated to keep something open for those. They can't award something on top of the caps because I think the caps actually do mean something. So they're either
What
going
do they
to-
mean? What are the purpose of the caps as you see it?
I see the purpose of the caps as addressing the fact that we are addressing medical care. One of the purposes behind this whole managed Medicaid program is cost control. And the way the legislature did that is they resorted to having HMOs help manage that care. They've also created these provider service networks that will help do that. To be successful in that process, you have to have a critical mass of patients that are in your system so you can help appropriately manage that risk. That is precisely why they cap the number of plans. So in Region 1 and 2, where they recognize it's going to be hard to get somebody to participate there, they're incentivizing it by saying, we'll let you go somewhere else, assuming you can still reach an agreement with ACA.
It seems to me that when they changed to managed care, that I agree with you. There's definitely a limitation in the statute, but certainly there's a strong interpretation that the purpose of the limitation of the statute was to ensure efficiency on the part of ACA. In other words, instead of them having to deal with an innumerable number of providers, they would just deal with a very limited number of plans. So in other words, it wasn't necessarily to protect the economic interests of the plans, but it was to make things more efficient, presumably less expensive for ACA to work with. And if ACA finds that, well, under our interpretation of the statute, it allows 5 instead of 4, then it's not really violating the legislature's plan for the system.
I think if that were the case, then it would be at least 2 and no more than 4 in all of the regions, but it's not. It's geared to the size of the regions and the populations in the regions. So that's why Regions 1 and 2, and I forget what the exact numbers are, but it's smaller than Region 8. And the region that covers Miami-Dade and Broward, those regions are going to be larger than even Region 8. One of the regions, they could award up to 11. It had nothing to do with managing the efficiencies of ACA. It had everything to do with creating a market that would be appealing for one of these Medicaid managed care plans to go in and provide the services, not knowing how many particular patients they're going to have in their system. It was intended to help give them some sort of comfort that the market that they would be competing for these patients in would be limited and would not be wide open.
Does it make any difference? We talked about some other types of regulated medical entities like the trauma centers and the certificate of need. And in those, looking at those statutes, it requires the agency, ACA in one case and health in the other, to actually consider the economic interests of the existing licensees, for lack of a better word. But there's nothing like that here. So can't we presume that if the legislature wanted to protect the economic interests of the plans, it would have done so the way they did in those other statutes?
Well, unlike the other statutes, they don't actually generally set the hard caps that they set, is my understanding.
I
Here,
think they do for trauma centers.
maybe for trauma centers, but for certificates of need, it works off of other calculations. Here, the legislature went ahead and did those calculations as to what the appropriate level was. And I see my time's up. What I would argue is that based upon the undisputed record, ACCA's award violates well-established clear language of 409.974, and it doesn't matter if you rely on the clear language. The canons of construction uphold that. Best Care was not obligated to exhaust the administrative remedies. Article 5, Section 21 was a game changer for the exhaustion of remedies. Furthermore, ACCA's decision in awarding it was without colorable authority, and as such, the trial court was justified in its ruling. Thank you.
Thank you, counsel.
Morning. Two brief points in rebuttal. The first one is my friend on the other side referenced the Florida Public Employees Council case. We addressed that on the first 2 pages of our reply brief. That case involved a situation where this court allowed a party that was pursuing an administrative challenge to a decision by the Department of Children and Families to file a constitutional challenge to the underlying statutes in the circuit court. It's a very different situation from here. Best Care has not raised a constitutional challenge to the statutes at issue here. It's raised the same kind of challenge about whether ACCA complied with the statutes, and obviously constitutional challenges cannot be adjudicated in an administrative forum. The General Services versus Willis case, which is one of the cases addressing these exhaustion requirements, characterized this particular one as that's at issue here, as applying where there is no colorable authority for the agency's action and the APA does not provide a vehicle for a remedy. Here, the Florida Administrative Procedure Act does provide an explicit remedy for a party to challenge a procurement decision. Section 120.57(3) includes its own standards for resolving bid protests. It includes specifics as to timing of resolving bid protests. The APA has a process set up to resolve exactly the sort of challenge that Best Care has raised here. Best Care should have been obliged to complete its administrative challenge, including through appeal to this court, as it will shortly, rather than pursuing a separate state court remedy on exactly the same thing. For those reasons, ACCA requests that this court reverse the trial court's judgment, remand the case with instructions to dismiss the complaint with prejudice for failure to exhaust, or in the alternative, to enter judgment for ACCA on the merits. Thank you.
Thank you, counsel.